Some glitches. All right, there we go. Hi, everybody. I'm immigration lawyer John Khosravi. September 13th, 2002. Thanks for joining us today. We're here for our regular weekly chat. We've changed the time. You've probably used to seeing this on Wednesdays. We're bringing it to Tuesdays. So we'll see, all the banners and all the advertisements are always about Tuesdays. Hopefully you'll catch it and the announcements will go out. But we'll see, 5 p.m. Tuesdays, we'll change it to so we could talk with y'all better live and take your questions to talk about U.S. immigration to the best extent possible, to talk about general, educational kind of stuff to the extent we can, because sometimes we don't have all the facts, so it becomes hard to give good answers, but we'll try our best to give a picture of what's going on. For those watching the live show, just to let you know, we do provide free video consultations as a raffle, 3 a piece, 3 a show every 10 minutes. So all you got to do is like and subscribe and write consultation in the comment section. And my wonderful assistant, Katrina, will name off person 10, 20, and 30 minutes. We have 3 different people to talk in private by 15 minutes video to see what's going on with your case and be of help there in a private setting. We're live on TikTok, Instagram, Facebook, YouTube, and LinkedIn. So we take all your questions from everywhere and try our best to answer here. If you're interested in a marriage green card case, you're getting married, you're getting engaged, and you want to bring your foreign spouse to the United States, the first thing you should do is download the Ultimate Marriage Green Card Guide that gets into the details of what you need to know about the process before you even talk with a lawyer. You know what's up, so you can kind of test them and say, hey, what about this? What about that? And see if they know what they're talking about. Be your own advocate. Download it at marriageimmigrationlaw.com. That's marriageimmigrationlaw.com. And with that, let's get it started. So we got a question that popped up on Instagram. Imran asks, now it's an asylum case. I don't do asylum cases, so let's see what it says. It says, my asylum case is pending. I filed my marriage adjustment-based green card application. Should I withdraw my asylum case? If not, the USCIS can ask questions in my pending asylum case during my adjustment interview. That's a very intriguing question. So it depends on where asylum is. There's a lot of different things, so I can't give individual legal guidance, just say that up front. But we got to know, is your asylum case affirmative asylum with USCIS, or is it defensive? You're in court being removed and be taken out. So that's something I'd want to know, because if you're already in court, they may be more skeptical about the marriage. If your spouse is a green card holder, not a citizen, there'll be other issues. If your spouse is a citizen, some issues will be solved. But will they have an issue with this should you withdraw the case? My general strategy is not to withdraw an asylum pending case if the applicant gets married, especially to a U.S. citizen. And I wait till after the green card is approved before notifying the asylum office that we're withdrawing the asylum case, just to take it out of the system. Now, I have colleagues who said their marriage green card cases went to an interview with USCIS, and the officer said, I cannot approve the green card until you withdraw the asylum case. I have not seen a regulation, it might just be me, but I've never seen a regulation that said you have to do that. So if the officer forces you to do it, you challenge it, you talk with the manager or supervisor and say, why is that needed? It's not needed, and push them on it to push back, because the asylum case is your backup plan, so you don't want to get rid of that. Now, will they talk about at the interview? Technically, stuff you talk about in an asylum application is private, it's secret. It's not meant for a USCIS officer at an adjustment of status interview based on a marriage case to talk about. This is something between you and the asylum office. Now, will they do that? Maybe. They're not supposed to. But if you had my office, we prepare for everything. But I'd want you to go in with an attorney in such a case, so the attorney could jump in and say, that's not an appropriate line of questioning. Here, we're analyzing a marriage case, look about their marriage, their background in that sense. Now, if your asylum case had some facts, like, you were arrested or for some sort of crimes or something like that, that may come up. It's in your asylum case, but, it may come up there as well. So it depends on what the issues are in your asylum case. But it's not something we'd want to talk about. It's not appropriate. And so we challenge that. I've done several cases like this. Once a year, every year I just have one case where they have an asylum case pending and they file for adjustment. Yeah, it's like once a year. It's not too frequent, but it does happen. And so we do that kind of stuff. But that's I just pretty thorough answer to your question. Thanks for on Instagram. Thanks for coming and asking a question. Okay, any updates about I-751s? No real updates from Malipa. Natalia asks, do you have any rough estimate how much money a K-1 visa from I-122 green card is? Trying to save as much as I can. It's not a question I can answer. It depends on the firm you use, your background, your personal issues, if there's extra work, less work. If you have, for example, if you make enough money yourself, you could deal with the affidavit of support, the I-134 and the I-864. But if you need a joint sponsor, that creates extra complication. If the joint sponsor is using assets as opposed to income, that creates extra complications. If your fiance has any criminal history or inadmissibility issues, that's extra stuff. If you don't have enough bona fides and they're questioning your relationship, that requires more work, more legal work. So it's, some people, there are law firms that commoditize it. So every case is an apple and they sell apples for $2. But I look at everyone as a human being, and every human being is different. So if I just say same price for everybody, a lot of times I'm gonna be overcharging people just because I just fixed the price, and I got to make sure it covers all costs in case some case goes bad. That's why I always try to review each case, see what's needed for that case, and limit the cost of that so it could be fair to people. So laws is just the way it is. Some people will commoditize it and tell you a fixed fee and all that kind of stuff, and you can ask around. Our firm doesn't do that. It's a personal concierge experience, so it's something completely different. But I understand, money's money, and you don't want to spend too much money because it's a cost. Things are getting expensive. But that's the best answer I have to that. For the level of service I want to bring, I really got to know the case and fine tune it. So my office can't really help you with, talking about how much prices are. Now, thank you for your question. Etiquette asks, how long does it take USCIS to transfer to National Visa Center an approved I-130 filed I-824? So let's back up and see what that means. Quick note, the Great Invisible asks, what happened? I thought it was Wednesday. Yeah, we changed the time to Tuesdays. Wednesdays are my work days where I work on cases and don't do meetings, and where sometimes need to go out. So I just thought it easier to bring out Tuesdays where I have meetings all day too. It's a different kind of setup for me on Tuesdays. But going back to the question, US Etiquette 28. Sometimes people, when they file a Form I-130, they list that they want to have the case completed within the United States, but their spouse is overseas, so they can't complete in the United States. They have to go to the U.S. Embassy abroad. So in those kind of cases, when you make that mistake, you have to file an Form I-824 and request that USCIS send the approved case to the embassy instead. Unfortunately, it's like spending a bunch of money, and it's going to take a while. But the question is, embassy approved I-130, and you file the I-824. Getting the I-824, the request for then transfer the case to U.S. Embassy, takes between 3 months to 1 year, maybe longer on average. There's a huge range. Once it's approved for USCIS to actually send the case to the National Visa Center, can take anywhere from 1 week to 6 months. And both ends, both getting the I-824 approved and transferring it to the NVC. I've seen many, not my cases, but I've seen other lawyers have to sue the government to get them to do it. Unfortunately, I-224 is just, for some reason, this form that creates a lot of problems. It doesn't get done fast, and when even if it's approved, the action you're requesting many times doesn't happen until you call them 50 times to write letters and get congressional help and ombudsman's help, and even threaten to sue them until you get it moving. So always, for those filing on your own, particularly, the last thing you want to do is have to file a Form I-824. It's a nightmare. You really want to pay attention on your Form I-130. If your spouse is overseas, you want to list that they're overseas. Now, there are cases where you get married and the person you marry has a child already. So that person might be in the United States. You file for adjustment status. They get the green card, and then they have a child who's with the actual biological parent. Let's say the mom's the wife who gets a green card within the United States, and her daughter is overseas. You have to file an I-824 to get the case, once approved within the United States, for the mother to be sent to the embassy. There's no choice in that, so you have to deal with the I-824. But what's important there is file the I-824 with the Form I-130 to make it faster, so you don't have to send it afterwards. So that's just tips from experience stuff to do. A lot of lawyers don't know you can file the Form I-824 with the I-130 or an I-140 for employment-based cases in those scenarios, but it's in the policy manual. You can do that, so it's important to know. So hopefully that helps. Thanks for your question. Jordan, one of our regulars, says, hey, John, is it possible to work on campus at a vocational school with an M1 visa if it's related to a course of study? Let's see, I don't handle too many M1s. If you have an F1 student visa, you can work on campus. You have to tell your DSO, designated school official, and they'll update your I-20 to reflect that. So that's something doable. M1s is probably the same, but I so rarely deal with M1s, which is kind of a student visa. It's particular for a vocational school. If you're in flight training, for example, or music training or something like that, it's probably the same regulation, but because I don't handle M1s, I haven't read that particular one, how to deal with the scenario. But for F1s, it is possible if the school approves it, probably the same for an F1, but I can't say for certain because I don't deal with the regulation enough. Great Invisible asks, what happened? I thought it was Wednesday. Yeah, we've moved things to Tuesday. Faiza asks, hi, I live in Virginia. I want to change my mother name from my adopted mom to my biological mother for my naturalization application. How can I do that? In general, when you're filing for naturalization, you can apply to change your name with it. Now, in general, the reason why I say that is a lot of USCIS offices are not offering that option because for you to be able to legally change your name at citizenship through the naturalization process, when you're doing your oath ceremony, there has to be a judge present. And many of these oath ceremonies don't have a judge to come and do it, so they don't bother doing it. So, for example, in San Francisco, or even in LA right now, if you request a name change, and it could be whatever, it doesn't have to be to your biological, that stuff doesn't matter. Whoever, if you could change the last name to my last name. It's doable as long as the officer proves it, which I don't see a reason why they wouldn't do it. But in San Francisco, for example, they just tell you at the interview you can't do that because at their oath ceremony, they won't have a judge, adjudicating it or making a decision so they can sign off on the name change. So that's a big factor there. The other factor I want to make sure I know about, and that this would require individual review your case, is I got to see how you got your green card, what you listed on your paperwork, to make sure you got your green card. There's no errors in there that become problematic because you have an adopted mom. Is there a potential that you got your green card through her? What kind of case was it? Did you mention this was your adopted mom? Some people might have said this is biological. I got to look at the paperwork and make sure there's no errors that could come back and be problematic in citizenship, so that could cause you to even lose the green card. So that's something you want to be cautious about before filing. But with regard to your specific question of name change, if your field office accepts name changes, then it's something to do. Or you could just contact the local courthouse and you could talk with them there and deal with it. So that kind of fully answers your question. But thanks for your question, Faiza. Okay, now one thing, I'm in Los Angeles. And I'm in a small room here, and it's getting hot. I'm starting to sweat. I already turned on the AC, but it's a hot room, and I couldn't find a shirt, so I got a long sleeve shirt. That wasn't a good idea in the middle of summer to wear. So you're gonna see me sweating. It's not because the questions are tough. It's just because it's hot in here. So we got some more questions coming on Instagram. Jay Etiquette follows up. Thanks. I schedule both inside and outside processing, but my spouse is outside, and I-130 approved over 2 years. So you cannot do that when you're submitting an I-130. There's a question on there for a marriage petition or just a family petition that said, are you going to do the case inside the United States, or are you going to do someone outside? You have to choose one. If you do both, USCIS will randomly choose it. In your case, it chooses it against you to say the case is within the United States, and you have to file an I-240. So make sure to never, for those starting the process, never on your I-130 mark that you're doing adjustment of status and consular processing. The best and safest thing to do is always mark consular processing. Because if you're going to do it through the embassy, then, and you change your mind and do adjustment of status, you just submit Form I-485 and it's fixable, and you tell the embassy it's fixable. But if you submit both or USCIS and the file stays with USCIS and you need to send outside, you got to deal with Form I-240, which is expensive, time consuming, all that kind of stuff. So it's not something that you want to do, etiquette, but thanks for letting me know. It's good to share that information with people. Fatima asks, Faiz, thank you. Faith asks, I won a consultation last week. I emailed your office. No one answered. Well, I answer every email. So try sending it again. You might have sent it the wrong place. The email is info@jqklaw.com. And I'm looking at my list of people. Yeah, Faith Moya 321. You are the winner from last week. I could see. I didn't get your email because I check all the emails. There might have been some error. Just email us again. Matija says, how Canadian citizen move to the United States and get a green card? So how can a Canadian citizen move to the United States and get a green card? Well, it's the same options that any person in the world has. The only difference a Canadian may have is that there's a non-immigrant visa, a temporary work visa called the TN, a NAFTA treaty. Now they changed NAFTA's name to something else. And that allows you as a Canadian citizen, if you have certain education experience history, to go and work in the United States for a company that will petition for you. Or was going to hire you. Other than that, it's the same for everything else. There's family-based, there's employment-based, which includes investment or starting a business, national interest waiver, extraordinary ability people. There's asylum, which is probably not going to work for a Canadian citizen, but it's the typical route everyone has. It's just too broad a thing to talk about here, but that's that. All right, so we have a question here on Instagram. Shahbad asks, I got a rejection due to 214B after 10 months administrative processing, July 7th in Paris, U.S. Embassy, but I want to apply again with F1 for a PhD in October. Do I have any chance I have to go to Paris Embassy again? So this person, it seems they may have applied for a tourist visa, and they got denied after their interview, after waiting 10 months after interview for a decision. So that sucks, but they got denied for 214B, which means that the U.S. Embassy is afraid that you're going to come to the United States and not go back to your home country. and so they don't trust you that you're going to go back home. So sometimes they do that just because it's an easy way. You can't challenge that denial. So it might be other issues involved in your case that they didn't feel like writing about, so they just did 214B. But one is, if you're doing a student visa or a tourist visa, essentially you could go to any embassy as long as you speak English and can talk with them. But you just say, I'll see the embassy will accept it right now because of COVID, some are shut down, but they probably will. Is it a good idea to do so? What will happen? It's up to them. I've seen cases be denied. Most times it's going to be denied, but I've seen cases be approved too. So that's as much as I can say. You just got to take a chance, just do the paperwork right, and that'll be it. Etiquette follows up. My I-824 form check is cashed. USCIS already has. Does it mean they're working on the case to transfer embassy? They're working on the case. It's so that once it's approved, they'll transfer to NBC. So really at the beginning of it, they got to approve the I-244 first. Again, that's going to take 3 to 12 to 15 months. Once that's approved, then they got to transfer it. It could be 1 week, it could be months. You might have to sue them to get them transferred. So I've seen both things. So when you're doing an I-24, because it's so unreliable as how long it's going to take, sometimes, for example, if this was for your spouse, you may just want to do an I-130 as well as a backup plan. So that's sometimes do. Now, if you're a green card holder doing it, an I-130 may take 2 years, so it might not be that bad. But if you're a U.S. citizen, many times we'll submit the I-24 and an I-130 just to see which one gets done first. Benson asks, hi, what is the difference between a CR1 and an IR1? Well, that's a great question. A CR1 is a conditional resident green card, and IR1 is immediate relative. But what they essentially mean is this: if you get your green card based on marriage, and your marriage was less than 2 years old when the green card's approved, and this was based on a law passed in the 90s because they're afraid people are doing fake marriages for green cards. So they passed a law that says if your marriage is new, which means you get the day you got married and the day your green card is approved and issued, is it within 2 years? If it is within 2 years, the green card that they'll give you is only 2 years before it expires. And so before that green card expires, to renew it and get a full 10-year green card, what you have to do is file another form. So that's what CR means once. It has conditions. It means that once you get the green card, you then 2 years later have to apply for another application to prove your relationship was real, is not fake. It's a lot of extra work. So you ideally want to get an IR1, which just is a 10-year green card because your marriage has been in existence for more than 2 years. You get it in, you get it out, and then you're done with that. So preferably do IR1, but if your marriage is new, you just got married, get the green card issued a year later, there's nothing you can do about it. So then you're forced into doing a CR1, a conditional green card, and doing removal of conditions 2 years later. Sue asks, can you talk a little bit about First Day CPT, Day 1 CPT, please? Sure, I'll talk very briefly about it. When you're a student visa holder in the United States, there are options that permit you to work. They're limited. Typically, people do what's called optional practical training, OPT, which is after you graduate, you can work for a year. And if you have a STEM major, you extend it for another 2 years. You could also do OPT even before graduation, and also a thing called CPT, curricular practical training, which is typically what people do when they're still in school but they want to work. They do a thing called CPT. And for CPT to do that, it has to be related to what you're studying. Now, typically for curricular practical training to be able to work while you're going to school, it has to be related to your field of study and help promote that as a course almost. Typically, you have to be going to school for a year before you could use it. But they have this exception called Day 1 CPT or First Day CPT, which says you could immediately start working with CPT, that permission, once you start school, if your school vouches that it's related to the work what your study is. It's necessary part of your studies to work. It's kind of on-job experience. So it's doable, but as you can imagine, there's a lot of fraud that goes around, which companies have made, universities or schools, that have figured out a way to give quick and easy work permits to people in a fraudulent way to say they're going to school, quote unquote, and give them work authorization so they can go work and stuff like that. So there's huge crackdowns that happen, and there is some skepticism when USCIS sees First Day CPT that it may be fraud. Now, it's not always fraud. There are a lot of schools that need it and do use it, but I'm always hesitant. You want to look up the school online and see what people are saying. You might look up the school and see they're under investigation, stuff like that. So I generally don't enjoy doing Day 1 CPT, but if you really need it, if it's really appropriate, then it's within the rules, but you just want to be safe. Now, I do want to mention our winner, Etiquette 28. Asked a lot of questions about the I-824. Might as well just talk in private. Our wonderful assistant, Katrina, named you as our winner of a raffle. Please take a screenshot of where you're watching this and email it to me at info@jqklaw.com. and I can send you information on scheduling a private consultation. There we go. And then we got a question on Instagram. Jay Vasquez asks, how long does the embassy take to review docs? Going on 4 months, SDO embassy. So the National Visa Center typically right now is taking 8 weeks to review submitted documents. If it's got longer, you need to contact them, write attention supervisors so they can get on top of it. It shouldn't go about 2 months. It does. They forget about all that kind of stuff, but you got to keep an eye on it and try to push them on it. But thank you for your question. Sorry that things are going so much longer. And Shabbat says, thank you for your help. Do you think that I became clear in terms of clearance for USCIS when I got the 214B after 10 months in AP? Whatever happened previously, even if you're clear, doesn't mean you're going to get it cleared next time. You might go through administrative processing all again. All right. So Ali Sayed asked, I'm a green card holder. I applied for my 9-year-old daughter who has Down syndrome. She is in Pakistan. If her visa process will be different for normal cases. Not necessarily. I don't think it will be. There's this idea of the public charge if your daughter can't support yourself, but if you're working, making money, that should be fine. I don't see anything particular problematic with bringing a child who has Down syndrome. I would maybe even make an expedite request to need my daughter here because she needs more support that can be provided in the United States, especially in light of what's going on in Pakistan. The Great Invisible House has submitted my I-824 at the same time as my I-485 was filed with my I-140. I-140 was approved through pre and processing in 2021. I got my green card April 2020 after my I-4 transferred to the NBC. If you got your, is there more to that question? That's the Great Invisible. Now I'm waiting for I-4 to get approved. The I-284 was filed as a fault to George for my wife and 2 kids. So April 2022. Yeah, you did the right process. And someone emailed me watching the videos and said you're wrong or lying. I filed my I-824 with my adjustment of status, my I-140, and they returned it saying we don't do this and stuff. But here's an example of a person that did it. Sometimes USCIS mistakes, or maybe that person just sent the wrong paperwork in. But contact USCIS, see what's going on. Maybe it's approved or something like that. It's hard to know what's going on with them. Just April right now, it's September. That's like 5 months. Yeah, call them, see what's going on. Maybe there's something they could do about it. But that's the thing about I-284. It's a mess. It's a complete mess. Okay, so Edgar follows up. Oh my gosh, get the I-130 approved. Took 2 years for another. They may do it faster, a new one. It's just if you want to spend the money, but it might happen faster. Nova asks, let's go to Nova. I need an update on I-75 application. It's almost 2 years now since I filed the remove conditions of my green card. I'm stuck on waiting an interview date. Nothing changed since last April. Yeah, unfortunately, the I-751 removal conditions is taking forever. Sometimes it takes more than 2 years. You may want to look at the citizenship by naturalization if you've been married and living with a citizen. You got to talk to a lawyer about that, get more details. That may be the way to go. iCloud, how much time for getting a travel document? Well, there's different types of travel documents. There's advanced parole, there's refugee travel documents, there's reentry permits. Right now, if you're talking about reentry permits, which is what typically people mean, it's taking forever. For over a year. I have one case 3 years pending, so it's almost worthless. The person came here. But at least you get it in, so if they challenge you on something later, say I tried to get it. At least says, thank you, bro. You're welcome. God bless you. Boss Bob says, hi, John. Will a contempt of court for child support in Missouri make a permanent resident inadmissible, deportable? Thanks. I don't know. I'd have to see the rules on the basis of the contempt and what happened with it, stuff like that. I just don't know the answer to that. I can't give the answer on that. So I know the facts. Now read the contempt order to see what it's based on and review the rules. And it comes to a factual basis. So I'd have to know more information about it. I do want to announce another raffle winner. Ali Sayed, thanks for watching. And just take a screenshot where you're watching this. Email it to me at info@jqqlaw.com. We'll do a private consultation about your case. Vikram asks, how long is it taking to renew my EAD? Mine is expiring in January. Renewing EADs anywhere from 3 months to 12 months on average. It's a huge average. Depending on what kind of EAD you have, you may have an automatic extension. So you got to see what type it is and look it up on the website. You will always want to file your EAD renewal as early as possible because of the delays that happen. You could do it 180 days before it gets expired. So you want to jump on it if you need something to hold you over. 29 Super C, what a regular says, hey, good night, Attorney Kostravi. How are you live today, not tomorrow? Conference to attend, I suppose, or something came up. I just changed the time for those regular viewers like 29 Super C. Brought it to Tuesday at 5 p.m. It used to be, yes, last week it was Wednesday at 6 p.m. But a lot of times on Wednesday, 6 p.m., I've been out. So it becomes easier to be consistent on Tuesday at 5 p.m. That's really it. But thanks. Good to see you. And we have people watching the show for like almost a year and a half now, regular watchers. So it's wonderful. Bilal asks, pending affirmative asylum can apply for EB3, 2-year pharmaceutical U.S. experience. How much time do we have? So, um, typically, if you're going to file for, you could EB3 petition. Yeah, you could always do that. That's the form I-140. You could do that. It doesn't matter. What your real question is, can you file for adjustment of status if you have an affirmative asylum case pending and your existing status has expired? That's the real question there. And most of the time right now, 9 out of 10 or 99 out of 100 times, they're going to deny that case because you have not maintained a status if your status has expired and more than 180 days have passed. So that's it. That's a very specific answer to that. Most likely not, but some field offices approve it. Benson asked, does premium package work for CR1? No, it doesn't. Shahzada asked, how much is the wait time for immediate relative, spouse, or U.S. citizen? Interview, 3 months, 2 years. That's the average. Jordan asked, what is considered part-time or full-time work by USCIS, number of hours, etc.? It depends on what you're looking at. So different types of visa categories will label it differently. For example, in EB5, the investor program, you get a green card, you have to hire 10 full-time workers, and I think they consider full-time like 30 hours for that or something like that. For me, it depends on the context, and sometimes just argue it, saying the IRS says this much, or in these cases consider this much. And I see it as the context of what it's in. Doesn't really pop up in most of the cases I do, but that's the answer to that. Boss Bob says, thanks again, you're welcome. Bilal asked, my employer is ready to sponsor me. I don't see asylum interview are scheduled soon. Yeah, unfortunately, asylum is really pending and backed up. It depends if you're out of status. I mean, having asylum pending is not status. It just means you could stay here until a decision is made, but you're out of status mostly. I don't know if these are the case, but usually it takes so long you come out of status. Your tourist visa you have ends or something like that. And so you have to have existing status to be able to file for adjustment of status, or else it's not going to work. Randomly, I see USCIS office approving it despite that, but more and more nowadays they're cracking down and not doing it. This area is ripe for lawsuits. They have the money and they want to do lawsuits. That's sue the government and say, why is there this inconsistency? Judges, I had a friend that sued on it, but the court didn't want to argue it, and they just found some other reason to get the case out. But it's a big issue. This I've talked about a lot, and with a lot of lawyers, it's an issue we deal with a lot that comes up, especially with long asylum delays. Most asks, hi John, can someone with a current pending CR1 application apply for Canadian residency? First of all, Canadian residency, I don't know what the rules are there, so I can't tell you about that. But the idea is if you have a pending green card case in the United States, can you file for residency in another country? It doesn't matter for here, but once you get the green card, you're not supposed to really be residing outside the United States. You're supposed to be a resident here, but you can start the process. I need to know more information about the facts and see what's going on, so I would be careful how I answer that, but most likely it's not a problem, but I really need to know more facts. The Great Invisible follows up. The company lawyer said if I do an I-130 that will take longer and that I have issues filing I-864 since I haven't filed taxes before. What do you think, or can I expedite the I-24? You can try expediting the I-24. It may work or may not. I-130 may take longer, it may be faster. It's a backup option, but who knows? And for your I-864, a lot of lawyers have different opinions on this, and I think a lot of them are wrong. By the time the I-130 is approved and the case goes to the National Visa Center, you'll have your 2022 taxes. And that 1 year, you have enough money, and you'll have continuing working pay stubs. So that'll be enough for me. I'd file a case like that. But I'll say 80% of lawyers would not accept that for I-6 after the store filing. But I've never had an issue with it before. So it's an extra cautiousness that the lawyers have that I haven't had. But you got to look at your own case, see what's going on, and make a decision. Benza says, thank you. What is the wait time for CR1? It's all over the place. 1 year, 2 year, 3 year, it could more. It's really how it goes. My assistant said you're a winner for a raffle, Benson. So just take a screenshot where you're watching this and email it to me at info@jqqlaw.com, and I'll reply with guidance and information on scheduling a private video consultation, which is part of our free raffle we give away each show. That was our third one, so we ran out. So new viewers, come again next Tuesday at 5 p.m. Pacific time, and give it a shot and get a raffle. We give away 3 different consultations in this one. So let's take one more question, and then we'll call it a day. Sesmas asks, can I apply for removal conditions green card and apply for citizenship at the same time if my marriage is 3 years? Well, it's technically not possible to do that. So when you get your green card, you file for removal conditions between 1 year and 9 months after getting the green card approved at 2 years. So there's a 90-day window before it expires in 2 years that you can file for removal conditions. For you to be able to file for citizenship, the earliest you could do it if you satisfy all the other rules is a 90-day window before you have your green card for 3 years. So you have to follow removal conditions. It's impossible for you to file for citizenship unless you're married to a military officer being stationed abroad or something like that, or a person married to whose spouse works for a U.S. company that's going to take you. So unless you're one of these exceptions, it's impossible for you to do that. You need to, not only is it that you have to have been married for 3 years with a U.S. citizen spouse and residing with them, but you have to have been a green card holder that whole time. They let you do that 2 years and 9 months or 2 years, 9 months, 90 days before the 3-year time. But you won't be able to file both at the same time. What would probably happen is file for removal of conditions, and a year later you file for citizenship, most likely on these kind of cases. And Miranda asks, how long are they taking the process in 400? Are they trying to close them in 6 months? Is that true? They say they're trying to close a bunch of cases 6 months, but it's September now, and they said that their deadline is September, and I'm not seeing that at all. How long does it take? 3 months, 6 months, 9 months, 2 years. It depends on your field office and what's going on in your case. And the timing that they give you on the website, their estimate timing, is almost completely unreliable. So with these cases, just with most immigration cases, you file the case and you live your life, and don't worry about case processing times because there's just no reliable answer. I can submit the same case for the same person. You imagine you submit the case twice, just two. They both get accepted. One gets done in 3 months. One takes 2 years. Why? It's just bureaucracy. But thank you, everyone, for joining us today. A lot of good questions. Good to see you all. We'll be back again next Tuesday at 5 p.m. Pacific. We've changed the time from 6 p.m. Wednesday to 5 p.m. Tuesday. So we'll catch you here live to take your questions via help, and we give away free video consultations. So just tune in quick, and we'll take it off from there. God bless everyone. Be safe, and we'll see you all next time. And we just got a question about the I-284. Proof told me to fill up they took that check. I don't know about your case, Nabita. I would have to see in private what's going on and see your paperwork. But sorry for everyone listening to the podcast. I know I just did that. I was trying to answer a question very quickly. I'll see you all next week. Bye-bye.